Exhibit 165. I wrote to the Illinois Department of Human Rights. I accepted the investigations on federal and state levels and understood from EEOC that federal and state work would be handled by them. I understood that I could file in federal and state court. That was my understanding. Later, in Exhibit 181, it said that I could only file in one court, or that document will relate to it. And the court ended up being only federal court. That was the same document, 165. Here's the second part of 165. It relates to a certificate of mailing. The Illinois Department of Human Rights. Exhibit 166. EEOC wrote to East St. Louis School District 189, directed the attention to Chris Hayes. It's a notice of discrimination, and it relates to a position statement and other information that is due, that was due 5/7/9/10. Here's the second part to Exhibit 166. It relates to the position statement. That consisted of 3 pages. Exhibit 167. Attorney Garrett P. Horner of Becker, Paulson, Horner, and Thompson, P.C. It's an extension request received by EEOC on the due date. Speaking of 167 again, just to be clear, Incorrect. 167 is Attorney Garrett P. Warner writing to EEOC, the Equal Employment Opportunity Commission, and he is announcing that he represents East St. Louis School District 189. He commits to the July 9th, 2010 due date of the information that's requested by EEOC. The other people that received a copy of this letter was Lonzo Greenwood, Teresa Saunders, and Princess Hayes, and another attorney for the district. Exhibit 168 Garrett P. Horner requests an extension. He requested a 10-day extension, and for the extension to include all of the 10th day. Exhibit 169. EEOC wrote to Attorney Garrett Horner the extension response deadline is spoken of here. A new deadline was given, and that no later than 10 a.m. on Friday, 7/16, was the new deadline date. This letter also mentioned that the extension was received, the request for an extension was received on the original due date. Exhibit 170. Attorney Garrett P. Horner hand-delivered. It's mentioned that this document was hand-delivered. It's the position statement. It consisted of 9 pages. Exhibit 170. It's Attorney Garrett Horner to EEOC. It's the position statement and response. Consists consisted of about 8 pages. Exhibit 171. EEOC enclosed the right to sue. This was number 3. Exhibit 172. EEOC writes the charges of discrimination regarding Local 382, General Service Employees, Local 382. Exhibit 173. The Illinois Department of Human Rights wrote to me about General Service Employees, Local 382. It says a copy of the charge was automatically filed with them. Exhibit 174. It's an EEOC charge transmittal, Watson versus General Service Employees, Local 382, regarding the investigation. Exhibit 175. EEOC position rules. They were sent to General Service Employees, Local 382. Exhibit 175. Total of about 3 pages. Exhibit 176. Then Attorney Chris Cooper for General Service Employees, Local 382. It relates to his position statement and an affidavit from Kim Haywood, who is a male. Exhibit 176. This particular part of it relates to the affidavit of Kim Haywood, who is a male. This affidavit is July 6, 2010. No affidavit was taken for or from Kim Haywood regarding the federal case. No deposition was taken from him. Again, General Service Employees, Local 382 failed to represent me In the 10-609 unwarranted hearing, that union representative Kim Haywood, who's a male, Linda Baldwin, and Bridget Howell attended. Donna Cameron confessed that her more than disorderly conduct toward me only ended after I stopped working on an added assignment and went to try to call for help. Still, these union representatives did not stop the harassment and did not prevent the wrongful termination of my employment. Exhibit 177, EEOC wrote to me, it's a notice of right to sue, General Service Employees, Local 382. Exhibit 178, I wrote to East St. Louis School District 189. At this point, it's an email for me to Princess Hayes. I am attaching a document to this email, and I'm asking you to please help with matters mentioned in it or forward it to those who can. And the email relates to Cobra Insurance. Here's a certificate of mailing regarding the same matter, Cobra Insurance, Exhibit 178. Part 3 of Exhibit 178 is the actual letter regarding the Cobra Insurance that was due to me, that the district never allowed me to have. Neither did they allow me to have unemployment benefits that were due to me. This is page 1 of a 2-page document denying me unemployment benefits and COBRA benefits more than relates to the exhibit, to Exhibit 8, which relates to Saturday Night Live. Speaking of the hellhole that can be made by individuals like me, are they meant to be hellhole? And it also relates to Exhibit 188, where U.S. Attorney General Eric Holder speaks of working to change the climate. Exhibit 179, relates to COBRA insurance. It's written to Teresa Saunders, and it's from a representative of that division related to COBRA insurance. The two-page document, Exhibit 180. EEOC made a note of me for my comments. It's related to retaliation and the concern for my safety. Here the representative chose to write the word stop. In my amended complaint, mentioned much earlier, a series of abduction attempts and actually being freed from one that was successful. After I became suspicious, I was miraculously freed. Once again, Saturday Night Live, the exhibit reference in Exhibit 188 from U.S. Attorney General. And the other news stories that you hear about in the news are more than real. Once again, it is chilling and hair-raising to know that once you stand up for yourself against bullies, they will try to have you, as I said earlier, to be off of the planet. Exhibit 181. St. Clair County, Illinois is what this relates to. It relates to the court there. Attorney Garrett Horner, the district's attorney, asked the judge that the case of East St. Louis School District 189 be dismissed. He also asked that the case against General Service Employees Local 382 be dismissed. No attorney was present for General Service Employees Local 382. The judge granted his wishes. Both complaints were dismissed from state court. This revealed that a partnership existed between East St. Louis School District 189 and General Service Employees Local 382, and that I had no help from General Service Employees Local 382. Exhibit 182. This is a news article from Lonzo Greenwood. It was printed in the East St. Louis Monitor newspaper. I took it as a confession to all of his being behind all of the discrimination and retaliation against me. Exhibit 183. It is a pay stub. My pay stub. And here it shows that General Service Employees Local 382 received pay from me, $148.04 was deducted from my pay at least every other week, or every other paycheck, I should say. I received no help from them, even after Donna Cameron confessed to Linda Baldwin, who worked for General Service Employees Local 382. She confessed to Linda Baldwin that her more than disorderly conduct towards me ended only after I stopped working on an added assignment and tried to call for help. Exhibit 184. Is some information regarding sexual harassment. I had informed Lonzo Greenwood about his own sexual harassment. I did that in a 5-3-10 unwarranted hearing. I shared with Princess Hayes of Bridget Howell, saying that I requested her for a meeting in Princess Hayes' office. In Exhibit 115, one of the two parts, I informed General Service Employees Local 382 of Mary Davis' sexual harassment, and even more can be spoken of, and was spoken of regarding that. About 5 pages to that document. Exhibit 185. It's an East St. Louis School District 189 document, and it relates to the equal employment opportunity, which I did not have. What pages relate? Exhibit 186. Relates to a union grievance, as shown in the videos. I prepared General Service Employees Local 382. I provided them with all the information and more that they needed to prevent my job from being wrongfully terminated, and before then to end the harassment, and they did not. Exhibit 187. It's an additional exhibit that was submitted to the attorney for the district. It's a complete deposition of the plaintiff regarding employment discrimination. Case number 311 CV 01005 JPG TMF. This is one of the two employment discrimination cases. Mine makes 3 that I referenced. Earlier, the other 2 cases were mentioned as Exhibits 5 and 6. Exhibit 188 This is a December 1st, 2012 Belleville News Democrat article. It relates to the crime that's mentioned even here in my case of employment discrimination. It mentions that it was going to be given attention by junior service employees working by U.S. Attorney General Eric Holder, That's a 3-page news article. Exhibit 189 is my 5th motion for an appointment of a court-appointed attorney. Once again, I filed 7 motions for an appointment of counsel, meaning the appointment of a court-appointed attorney. And as mentioned earlier, the first one expressed that he did not feel that he would be effective. He expressed that he had never handled a case like mine, and he invited me to ask the court for a different attorney. I expressed that I would continue because lengthy delays had been in place before one was finally appointed to my case. Still, he asked to withdraw, and he was permitted. A second person, as I mentioned earlier, was assigned to represent me. He asked to withdraw and eventually said that it was for ethical reasons. I later learned, not much later, that he did not have a license to practice law in Illinois and was appointed by the U.S. District Court to represent me. That motion has 3 pages. Exhibit 190 is a motion to continue. And it relates to general service employees looking for an agency. Once again, there are additional exhibits that were given to the attorney for East St. Louis School District 189 earlier. A list and description of those exhibits were displayed. I received a 12-13 document from the United States District Court, and it said defendant is entitled to summary judgment because plaintiff has failed to establish a prima facie cases of discrimination. This is number 3 in that document. As I always expressed in my request for an attorney, I have never been to law school. Even though they complimented my skills and abilities, the judges, I still always requested an attorney. The word prima facie, if I'm pronouncing it correctly, I looked it up in the dictionary, and it mentioned accepted correct until proven otherwise. So in my documents, I have expressed that I resisted the different sexual advances of the different employees, officials, and affiliates that sexually harassed me. I've expressed that Princess Hayes was asked by Judge Roberta Schallenberger from the employment office of the reasons for the unwarranted request. And Princess Hayes indicated that it was because I had resisted these sexual advances from specifically Mary Davis, and she said staff. My heterosexual, monogamous, and biblically based principles that my lifestyle is based on is easily understood from the beginning of time, and I should not have been asked to go to an unneeded and unwarranted setting to discuss that and to allow the school district to continue to retaliate against me somehow using that particular unwarranted request. So I proved that Princess Hayes' reasoning was not correct. In Judge Michael's January 31st, 2014 ruling, where he unfairly ruled on my case, he mentioned that I did not communicate effectively in the 10-609 unwarranted hearing. So that was the reason for the unwarranted request that Princess Hayes had spoken of. The 115th exhibit, which consisted of 2 parts, now it will consist of 3. The unwarranted hearing was summarized. East St. Louis School District 189 failed to produce their copy of the unwarranted hearing. Nowadays, I have a copy that will become available, and it, as this prima facie statement mentions, reconfirms that I spoke correctly in the unwarranted hearing. And in the unwarranted hearing, once again, Donna Cameron confessed that her more than disorderly conduct towards me only ended after I had to stop working on an added assignment and try to call for help. So that is the case. It has been more than unfairly ruled on.